Good morning, everybody. Thank you for joining us for the February Enterprise Risk Management Toolbox webinar. A couple of housekeeping notes before we get started. If you've dialed in by phone but you haven't logged in by web and you would like to see the slides that will be shown, please point your web browser to readytalk.com. In the box where it says Participant Join a Meeting, enter the same access code that you used to join the call, 9879821. Please stay aware of the level of background noise in your area. We are leaving the phone lines open so questions can be asked as they come up. If it starts to get noisy in your area, please put your phone on mute, which you can do, but if you don't have the mute button on your phone, by using the ReadyTalk controls, *6 to mute a line and *7 to unmute it. Please do not put your phone on hold during the call, as that will cause your hold music to be transmitted to everybody else. You can simply hang up, dial back in when you're available, and it will not disrupt the call. Now, if I may introduce our presenter, Nicole Craig, with the University of California's Office of General Counsel. Nicole has been with OGC since 2011. She monitors risk management related to litigation, particularly in the general liability area, and provides counsel to risk management staff on insurance and contractual issues. Before joining OGC, she worked for many years as in-house counsel for Safeco Insurance Company and has also worked for private law firms, litigating tort and insurance coverage issues. She has extensive trial experience and serves as Judge Pro Tem in small claims in San Francisco Superior Court. Nicole?
Thanks, Emily. Good morning, everybody. We're here to talk about waivers. This is essentially a reprise of the Risk Summit talk that I gave, just a little more generalized. My understanding from Emily is that the phones are open. And so if you have a question or comment or want to heckle me, feel free to just jump in and interject. And we can have this be a little more lively presentation and less of just a talking head. So I'm going to start out with just going over the things that I will cover in this talk. And then, of course, we can cover questions and answers if there are any that haven't been covered during the presentation at the end. We're going to talk about what a waiver is, what you can and can't waive legally under California law, the requirements that the courts are requiring for a waiver to really hold water, language barrier issues, translations, things like those, how to deal with minors and waivers, retention policies, and the statutes of limitations that affect waivers. We're not going to go over UC-specific waivers. This is a little more broad presentation, but we can kind of touch on questions if anybody has questions on specific waivers. So what is a waiver? And just so that we're all on the same page, for those of you that have kids or have done any kind of recreational activity, I'm sure you know what they are. They're the sheet of paper that you're given before you participate in the activity or before your child does, basically saying that in consideration for the permission to participate, you or your child is forever waiving any right to sue the provider of the activity. It is a binding legal contract, so when you read it and you sign it, it's binding if it's properly written. It's what we call an exculpatory contract, and California courts favor exculpatory contracts. And in this case, the courts like them because it reduces the cost of providing interesting and exciting recreational activity that otherwise probably providers wouldn't participate in without waivers. For example, ski slopes. It would be much too expensive to operate a ski slope without any kind of waiver because the injuries are just kind of their inherent risks in the activity. So the courts understand that. They want people to go out and do interesting activities, exciting activities, thrilling activities, and so they do favor waivers when they can and when they're properly worded. There's three purposes I see to to waivers. There's anecdotal evidence that they actually prevent lawsuits to begin with, that when someone shows up and signs a waiver, participates in the activity, and gets injured, sometimes their first thought is, well, I signed a waiver, so I'm kind of out of luck. So it can prevent lawsuits to begin with. Once they do, if for some reason they do go to an attorney and take the waiver with them, usually attorneys will look at the waiver and say you need to either find somebody else or you don't have a case. Again, if the waiver is properly worded. There's also anecdotal evidence that waivers may encourage safety in the actual activity, that it's kind of a thought process on the part of the participant when they do read a waiver that these are some of the inherent risks that could include minor injuries, scrapes, bruises, all the way up to life-threatening injuries. Sometimes people may think twice about, actually snapping on that head protection and taking due care. There's a couple of different kinds of waivers. We'll just touch on this very briefly. There's the standalone contract that the university usually uses when it is participation in a specific activity. There is a waiver that can be included as part of another document, and an example of that is the club memberships, athletic club memberships. Normally it will have a membership agreement, and then part of that agreement, somewhere in that document, will be a waiver of liability. And also at the university here, we use group waivers, which is a single sheet explaining the waiver and then a signature sheet attached to it that has multiple signatures. So I want to talk about what you can and can't waive using a waiver, because even though the participant signed something saying that they will forever release the university or the provider from any and all claims, actually in California the law is not quite so broad. So there are some things that you can waive using a waiver, and then there are things that the law will not allow you to waive, even if it's specifically worded as a waiver in the actual release. You can waive accidents, just plain old accidents, things that happen that are no fault of anyone. You can waive injuries that are inherent in a particular sport or activity. Like an injury inherent in baseball is getting hit potentially in the head by a baseball, which is not necessarily through anyone's negligence. It just happens in this particular sport. And you can also waive negligence. So you can waive the negligence of co-participants. You can waive the negligence of the provider. What you can't waive in California is fraud. For example, if the waiver has been obtained through fraud, example of that is if the wording is hidden. We call it lost in the fold. If for some reason there is something covering it, it's a tripartite folded flyer, and the waiver is kind of hidden underneath the fold. If it's an agreement to, if it's labeled an agreement to participate or a sign-in sheet, and the type is very small for the waiver, that could be considered fraud. Or if the provider represents, well, sign this, but we don't have any insurance, so you're going to have to sign this to participate. That would be considered fraud. Intentional injury is also not covered. For example, if you sign a waiver saying you're going to participate in a baseball game and one of the co-participants clocks you, then that would not be covered under the waiver, and that other participant would be able to sue both the other player and the provider of the activity. You cannot waive gross negligence, and gross negligence is something that is so beyond the pale of negligence that it just is not covered by public policy. gross negligence, the wording for that in California law is the lack of any care or an extreme departure from what a reasonably careful person would do in the same situation to prevent harm to oneself or to others. So that is not covered by a waiver, even if you have a valid waiver. And the last point of an example of what's not covered by a waiver is an important one, as are the ones before this, but this is a particularly important one. Violations of a statute cannot be waived, no matter how the waiver is worded. And this is an important one, particularly in a university setting, because we do have older buildings, older facilities, and code violations would be included in this. If an injury is caused by a code violation, then a waiver probably will not cover it. And let me give you an example. There was a case in 2006 called Capri versus LA Fitness International, where a club member, an athletic club member, went to the pool and slipped on the pool deck. And the court, of course, the defense attorney waived the waiver and thought they were going to get a motion for summary judgment. But the court said, no, sorry, this fall, the plaintiff has showed that this fall was caused by code violations, particularly in the surface of the pool deck. And releases or waivers just do not release you from a violation of a statute. So that one is an important one, as I said, particularly in a university setting. You also can't waive negligence of a provider, even just plain negligence, if the court finds that the waiver is contrary to public policy. And this is where a lot of people, it gets a little confusing. A lot of people get stuck, attorneys get stuck on this. It's kind of a convoluted analysis. So I'm just going to kind of touch on these points. There won't be a test afterwards, I promise. There was a waiver in a particular case involving the Regents of the University of California. This was a seminal case that's in all the law books that beginning lawyers or law students learn, torts one, called Tunkel versus the Regents, and it was a case where a patient at UCLA Medical Center came in through the ER and was being admitted and signed a waiver saying, in return for being treated here, I hereby release the Regents and all of its employees and doctors, etc., from any negligence that might occur while I'm a patient here. Well, there were a couple of physicians who allegedly malpracticed on this particular patient, and when he sued, the Regents, brought forward this waiver, and the court said, no, you cannot use a waiver in this kind of case because it's contrary to public policy. And here are the criteria that this court, this is the California Supreme Court, and now every court has to follow this, kind of an analysis of situations where a waiver would be contrary to public policy. Number one, the activity or the activity basically is generally one that's suited for public regulation, school buses, health care, things like that. Number two, that the service that's being provided is of great importance to the public, again, hospitals, health care, school buses, etc. Three, that the service is available to anyone in the public if they're qualified. There can be some qualifications that are required, but it's generally available to anyone that wants to and is qualified to participate. Four, that there's vastly uneven bargaining strength between the person that's signing the waiver and the provider of the activity or service. Or in this instance, in Tunkel, the court observed, look, the guy's in the emergency room. He's not gonna. There's no negotiation table. There's no mediation room. He's not going to be negotiating his rights. He's there to get service. He's not going to go somewhere else. So it was really unfair to expect him to sign this basically under duress, and that the university held the superior bargaining strength, and that it was an unfair bargain, essentially. 5, that is not negotiable. So it's either take it or leave it. Either sign this thing, or you can't get the service. And of particular importance was that number 6, that the service basically placed the person under the absolute control of the provider. So in other words, the person in this particular situation obviously cannot operate on himself. He can't protect himself from any medical negligence. They basically have no opportunity to take whatever care they need to take to protect themselves, and court felt that that played into a waiver that violated public policy. So those are kind of the elements of TUNCL. Again, it's convoluted. Courts don't even understand it all the time. It's open to interpretation. So, but it does give you a flavor for what they look at, and when they're looking at, okay, where's a situation where it's generally suited for public regulation, that's of great importance to the public, that service is available to anyone, who on our campuses fits into that kind of picture, and basically our students. So when our students show up on campus first day of school, can we hand them a waiver and say, okay, in return for us providing you an education, we would like you to waive any rights that you may have, including our negligence, for anything that would happen to you during the, while you're on campus or getting educated? And the answer is no. we cannot do that. And this is particularly true when the activities that the student is participating in is required by the course or the curriculum. So the TUNCL criteria would apply there, and you can get a waiver, but it's not going to be a valid waiver. They don't have a choice. They do have a choice to choose the course, but once they're in the course, if an activity is required by the course, they've essentially lost their ability to choose. So for required activities, the waiver doesn't hold any weight. So those don't apply, and it's not valid to ask for a waiver for required activities. Now, for voluntary activities, you can use a waiver. For example, if for a student, if there's a 5K run on campus and it's not involved in any class necessarily, or even if the class is going to do it on the side, a bunch of students are going to do it on the side or participate as a team from the class. If it's not going to affect their grades, it's not required by the teacher, then a waiver would apply, and it would be a valid waiver. So again, just to kind of touch on this quickly, examples where TUNCL applies, in other words, where the waiver would be considered violation of public policy. In our instance, it would be our university hospitals and clinics for patients, for campus classes, intercollegiate sports. Again, yes, there is a choice to participate in intercollegiate sports, but once you're there, you have to participate as the coach instructs you. Internships or externships here or abroad, or the public attending a game or a major campus function. The other area, any questions so far? I'm almost afraid to ask.
The chat's not coming up for me. What about like physical education classes that are part of the academic curriculum?
That would fall under TUNCL. That they basically don't have any bargaining power. They can choose the class, yes, but once they've chosen the class, if it's a physical education class, they have to participate or they'll flunk. And so those instances we would not normally use a waiver. A waiver wouldn't be valid, my argument.
The PE classes are not for credit. It's pass, no pass. Would that still apply?
You know, it would be open to argument. I would say that a court would likely find that a waiver would not apply. But
okay.
Certainly, you know, and we'll touch on this a little bit later, that when in doubt, why not get a waiver unless there's some reputational risk to doing so. I mean, you don't want to look like you don't want to look like, okay, well, we're going to kill you if you come on campus, so you better sign this waiver.
Right.
You know, that's not how we go through life, and probably the number of times that we've all been asked for waivers is pretty minimal, and you know, that's probably how it should be. So I think it would be arguable. I would guess that a court would say, no, a waiver doesn't apply. You know, even if it's pass, no pass, still they could not pass. And once they're in the class, in order to pass, they have to participate.
It's it goes on their academic record as a no pass. So even though it doesn't affect their GPA, it still would be on their record. Yeah.
Right. Now, when they sign up for the rec center, though, to just you know, use the weights, go for swim, things like that on their as part of their just student status, they get access to that. Then absolutely, that should be waivered within an inch of its life.
Yeah. Okay.
All right. So let's talk about employees, because employees kind of fall out of the TUNCL or the public policy issue, but we still cannot normally ask our employees who are acting within the scope of their employment to sign waivers. Otherwise, gosh, we would be doing it for every employee that we, you know, assign a vehicle to, or our window washers, or, you know, people that are doing, you know, somewhat risky activities as a part of their employment. The reason that waivers don't hold water with employees that are acting within the scope of their employment is because, again, there's a imbalance in bargaining power, and courts have found that where an employee or someone else, for that matter, doesn't have any bargaining power or the ability to say, no, I really don't want to do this activity. It's called an adhesion contract, because it's really by force and fear and force of losing your job. Otherwise, unless you sign it, those kind of contracts are not valid. So normally you would see any kind of waiver that an employee signed for injuries that might arise out of the scope of their employment invalidated. I'm not going to go into indemnity in this particular presentation, but the indemnity section of the waiver that we use is separate and apart from the waiver of rights, even though it's in the waiver. But I don't want to go into that. So, but as far as the applying to employees within the scope of the employment, if the employees are doing something that's not within the scope of their employment, that's separate and apart, and this includes volunteers as well. For example, if they all agree, if all of the employees in a particular department agree to go do a beach cleanup just for the heck of it, then a waiver for the transportation and the activity could be required, and it would be valid if it was properly worded. So let's move on to what the courts in California require from a waiver in order to make it valid. So once it's passed the test as far as whether, you know, it's allowable under public policy, it's not for an employee within the scope of their employment, what do the courts look at on the actual surface of the waiver to determine whether or not it's valid or not? And the first thing they require is clear, unambiguous, comprehensive, and explicit language of a release or a waiver. So they want to make it absolutely clear to the person that's signing it that they are indeed signing a waiver and they are releasing their rights to sue under particular situations. But on the other hand, the same courts have said, but you need to avoid convoluted, lengthy, or legalese verbiage. So on one hand, they want clear, unambiguous, comprehensive, and explicit language. And on the other hand, they're saying, but we don't want you to go overboard and make it so legalese and long that people just aren't going to read it. So one court observed that this kind of puts attorneys who are drafting these agreements between the Scylla and the Sherbitus. For those of you that remember your Homer, and I don't mean Homer Simpson, I mean Homer, the Greek Homer. It really makes it puts you between a rock and a hard place, and it makes it difficult to draft a proper and valid waiver. And that's why I always recommend that when you go to change a waiver, even though you think you're doing it right, it's best to have an attorney look it over and just make sure that you've done what you want to have done. So it's very important. It's difficult for a lot of attorneys to draft proper waivers, much less lay people. The other thing that the courts require in California anyway, and all of these things apply only to California, is that the releasing language be conspicuous. The courts do not want it hidden in a 3-page dissertation about how fun it is and how much fun you're going to have river rafting, and then, oh, by the way, these are some of the risks, and sign here. So they want it to be very conspicuous, and that's why we have headings on our waivers. Okay, waiver. This is the waiver part. This is the assumption of risk part. I have read, it's very clear exactly what it's doing. It's labeled waiver of liability, assumption of risk, and indemnity agreement. There's no question that it's a waiver and what it's doing. The font size is also important. We all know about the teeny tiny, unreadable legal font that you see on a lot of documents. The font size, the courts have said it has to be at least 8 point. I prefer it to be 12 points, just because it should basically be the size of the rest of the document font. Probably one of the most important things in waivers as far as drafting waivers is that it has to, if the provider wants to be released of its own negligence and the negligence of its employees, that the waiver has to expressly say that. It's not good enough to just have broad language that says, I release you from any and all claims arising out of my participation in this event. It has to also say, including, providers and its employees' own negligence, because without that, that it's not going to release your own negligence or the negligence of your employees. Just catch up here. So let me give you an example of how that particular requirement works. There was a case that involved a horseback riding stable in Marin, and anybody that's been horseback riding knows these releases that you're given before you're even allowed to touch a horse. But so in this instance, a woman had signed a waiver, basically the way I put it just a moment ago, that she released the horseback riding stable from any and all claims, and the waiver even went so far as to say, hey, we don't want to scare you, but horses, even trained horses, can bolt and run unexpectedly, and here's some of the other risks. It's kind of dangerous, etc. But it didn't have the language that released the stable from its own negligence. So this woman was a newbie. She had never ridden a horse before. She didn't know how to ride. She had told the stable she didn't know how to ride, and they gave her an old mare that was fairly tame, etc. But they set off on their trail ride, and the stable had an employee leading this line of horses. And for one reason or the other, I think she said it was to increase the enjoyment of everyone. The stable employee caused her own horse to gallop, knowing full well that it would cause all the other horses to gallop. So the woman's horse started to gallop. She fell off, and her foot got caught in the stirrup, and she got dragged and severely injured. And the court, even though the stable had the release, said, hey, she did not release your negligence or your employee's negligence. Yes, running away is an inherent danger of horseback riding, but the horse would not have run away if your employee hadn't caused the horse to start galloping in the first place. So it was a very fine line that the court walked, and it kind of illustrates how picky the court will get sometimes on the wording and how important proper wording is. Any questions so far? Okay. So on the waivers, I'm sure you've all seen them. It will spell out some of the inherent risks that people can think of. It's not necessary that a waiver spell out every risk involved in a particular activity. In fact, sometimes a lot of lawyers will tell you, if you list every single risk that you can possibly think of, the court may look at it and say, aha, well, you were very careful to list all of the risks, so this other risk that actually happened, you probably didn't mean to include it, and so it's not included. So we try to be as broad as we can and still spell out the risks. The courts, again, you don't have to spell out every risk, but if an injury happens, it needs to be reasonably related to the purpose of the release in order to be waived. And let me give you an example, because I'm not sure I put it very well. But for example, in the photograph that you see now, we signed a waiver saying, yeah, we understand that motorcycles are dangerous. We understand that they can tip over, they can skid, they can slip. A lot of things can happen on a motorcycle. But a court, if I got hit by an arrow riding a motorcycle, a court would say, yeah, no, that's you didn't release that. Nobody would have anticipated that somebody would be getting on top of a guy riding a motorcycle and shooting arrows. So that was not the type of injury that was contemplated by or spelled out even in the waiver. Any questions on that? So let me give you some other examples of what courts look at in evaluating whether a waiver actually waived a particular kind of injury. Excuse me. There was a case in 2002 where a club member at an athletic club membership signed a waiver that said, I hereby release da-da-da-da-da, whether I'm using the exercise equipment or not. So this member went in, went in and he was on the treadmill and he couldn't see the TV, so he got off the treadmill and he started adjusting the TV over his head and it fell on his head. And the court said, yeah, okay, that waiver's okay because it did say whether he was using the equipment or not. Because of course the plaintiff was arguing, well, that's not, nobody anticipates a TV falling on your head when you're participating at an athletic club. But the court said, yeah, whether using equipment or not, that would cover adjusting a TV. But on the other hand, there's a case where someone signed a waiver waiving the dangerous activity of auto racing. That's how it was worded in the waiver. But when he was sitting and watching the race, the cars going around the track, the bleachers collapsed. And the court found, yeah, that wasn't really part of the waiver. That's not really considered the dangerous part of auto racing. The dangerous part of auto racing is, debris hitting you, cars coming into the stands, things like that, but not the bleachers collapsing on their own. And the last example that I like to give that shows you how picky those courts get on this language and the intention of the waiver is that a diver rented equipment for scuba diving, just to go scuba diving from the beach. But the release that he signed with scuba diving company, the release said that it was for boat dives or multiple day rentals. And the court said, no, this waiver doesn't really apply. Yeah, he rented the stuff from you. He signed the waiver. But he was just doing a single day dive from the beach. He wasn't on a boat. It wasn't a multiple day rental. And so the court found, yeah, this does not apply. So, I mean, the first thing that happens is I'm sure that the next day the waiver was revised by the scuba diving company's attorney. So a case that is specific to the university that kind of illustrates what I'm talking about here is a case called Abbasi versus the Regents. It was a UCLA case for the recreational facilities, and the waiver was basically said, this is a waiver in return for participating in recreation programs. You hereby release da 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 da. The court, let's see, I think this. Oh yeah, the plaintiff was lifting weights using the weight equipment on his own. Where you just come in, you check in, you just do weights, and then you leave. But he did weights, and he got injured. And the court said, well, the waiver for participation in recreation programs. Well, he wasn't in a recreation program. There wasn't a program. He was just independently using the facilities. And so this kind of sparked the university to change the language to including any use of facilities. So that's kind of the UC specific case there. So let's talk about once you have a valid release, some of the problems that may come up, or at least some of the arguments of how to defeat it. Oftentimes, and I've dealt with this in dental malpractice cases with the informed consent form, plaintiffs have argued, well, yeah, they gave it to me, but I didn't read it. And California courts have found that there is number one, there's no obligation to tell the participant to read it. There's no obligation to make sure they read it. I mean, certainly if you rush them and say, here, sign this, don't read it, yeah, of course, not gonna buy that. But there is no obligation for anyone to actually read and understand a waiver. You just have to give them the opportunity to do that, and once they sign it, then it's kind of too bad. There's likewise no legal obligation to translate waivers into other languages unless you're doing business in a particular language. So in other words, if we have an outpost in China and everybody is speaking Chinese, business is conducted in Chinese, everybody is speaking Chinese, then yes, you would have an obligation to translate any waiver into Chinese. But here in the States, if we are conducting our business in English, which we do, there is no obligation to translate the waiver into other languages. It's awfully nice to do so for your general population and the parents and things like that, and we certainly do when we can. But there's no legal obligation to do so. So let's talk about minors, because this is often an area of much discussion. If a participant is under 18, in other words, a minor in California, a signature is required by the parent. There's no exception. They do not become adults just because they are attending our university. If they are under 18, a signature is still required by the parent. Now we know that that is not practical at all, and that's fine. You just have to realize that a waiver that's signed by a minor may not be valid. And I say may not be valid because in California, a minor is allowed and can enter into a contract. And that contract is binding. But the other part of that is that in California, if you're under 18, you can back out of any contract you want to. So it's a valid contract until they decide that it's not a valid contract. And you know, I'm willing to bet my first child on the fact that once that minor goes to an attorney, for some reason or other, that contract is going to be withdrawn. There is an exception, and this has nothing to do with waivers, but just so everybody knows, there's an exception to that rule that a minor can back out of a contract, and that is if the contract is for important activities of living, essential living activities such as food, shelter, things like that. Then those kind of contracts entered into by a minor are considered binding. But in our case, where it's participation in an activity, again, while it may be valid, while the minor wants it to be valid, they can invalidate it easily and without any kind of written notice. If a parent signs on behalf of the minor, which they should, it's not necessary to also get the child's signature. The parent's signature is binding on the parent, and that includes the parent's own claim. So God forbid if it ends up being a wrongful death suit, if the parent has signed, they have signed away their right to sue for a loss of consortium, loss of support, things like that. So any questions on that?
I had a question concerning, this is at UC Santa Cruz, and we're getting ready to start a summer camp. And we had been talking about the logistics of making sure of getting that signature before the first day of camp. And this is the electronic waivers question. Is that an option?
You mean are electronic waivers allowed, or?
Yeah. Are they allowed? Are they? Yeah. Is that something that anybody else uses in the UC system?
You know, I can't speak for the rest of the UC system. I think there are electronic waivers, and that's certainly something that we're going to try to move to, just mostly for storage purposes and for ease of use. In California, digital signature is allowed. It has to meet certain criteria that are outlined in Government Code Section 16.5.
Mm-hmm.
It has to be a system where the person is assigned a code to get in, that is particular to them, that the signature is capable of verification, or the electronic signature is. There's criteria that you have to meet, which most digital signature companies that kind of facilitate that are up on, and most programs, I think, are I think Adobe maybe has. I don't know what the programs are, but there are criteria that has to meet in order to be valid. But yeah, they are absolutely valid. I think nowadays real estate even accepts digital signatures on offers and acceptance and things like that.
Okay,
Does that answer your question?
Yeah, so they're valid, and so we just need to find out what the criteria are and set it up so that we're meeting that criteria.
Yeah, and again, it's California Government Code 16.5, and it's a list of 5 or so criteria.
California Government Code 16.5.
And you can email me later, and I can send you the citation.
Okay, thank you.
Okay. So retention is always, and this is a great segue into retention, because the digital signature makes it so much easier to have an all digital system as opposed to written pieces of paper. waivers never expire. They never expire. They are good forever unless they have some limitation written into the waiver. And there are some waivers that are written, in participation in this soccer camp that runs from this date to this date. In that case, the waiver would expire after statute of limitations ran after that last date of attendance. But in general, our general university waivers never expire unless there's a particular event date. And so it's kind of nice if you can to not have a begins date, ends date, because you could theoretically have that waiver on hand 30 years from now when the participant is in a swimming class and gets injured, and we have their rec center waiver from 30 years before, it's still just as valid as it was if the wording is correct and it covers rec center activities and facilities use. But in general, the ideal retention is 3 years past the statute of limitations for somebody to sue for any particular injury. So for a normal person, that would be 2 years past the date of whenever they stop participating. Again, if you have a specific date in the waiver, 2 years. I don't know where I got that from. It made sense to me, and I'm just drawing a blank right now. I know it's true, gosh darn it, but I just can't explain it at this moment. For minors, they're a little trickier, and the statute of limitations on any claim for injury doesn't start ticking until they reach the age of 18. So in other words, you have a 2-year-old, say for example, who is participating in the Easter egg hunt and gets injured. The parents don't, or the child, him or herself, doesn't even have to sue until after they've reached the age of majority plus 2 years. So that could be 23 years of age. So you have to kind of watch that if you're going to have dates on your particular waivers. So I'm not going to go into UC-specific waivers, but I just want to there's always a lot of discussion of, well, when should we ask for a waiver and when do we not need a waiver? And so I kind of want to give you some kind of, not ground rules, but just some guides as far as when to ask for a waiver and when not to. Because, of course, we don't want to be handing, I don't think anybody wants to be handing everybody that appears on campus or at their business waiver saying, yeah, we might really hurt you, so sign this. The guidelines that I kind of encourage is, get waivers for activities, and again, this is contingent on meeting the criteria for it not being an employee, student in certain situations. But for activities, involving an unusual physical risk, like runs, physical activities like that, any activities involving transportation, like if they are actually taking a bus or a group transport to do a beach cleanup, off-campus things, out-of-country things certainly, and other higher risk activities, not just generally every activity that there is. I usually look at it, ask yourself, is there more than a remote risk that the university or the university employees could cause injury through negligence? If the answer is yes, then definitely a waiver. So again, a fun run organized by UC. But employees volunteering for beach cleanup and they're transporting themselves, is it really going to the beach and picking up trash? Is it really going to cause more than a remote risk that the university or university employees would cause injury through negligence? Probably not. Or UC gives a grant money to send a student to Disneyland. All we're doing is giving the grant money. We're not actually driving the student there. We're not going with them. We're not going to be walking through the park with them. There's really not more than a remote risk that we or our employees would cause injury through negligence. So that's kind of the guidepost that I use to encourage people to really evaluate whether they need a waiver or not. Now there are a lot of situations, and I get asked a lot about situations that I call wobblers. They could fall on one side of the fence or the other. Maybe it's a good idea to get a waiver, but you could probably get away without having a waiver because the risk really isn't, raising a red flag. On those wobblers, I just find go ahead and ask for a waiver. If there's no reputational issue, or appearing like we're being really hard-hearted, if there's nothing like that, then why not get a waiver? Then what you have, at least you have a piece of paper. It may or may not stand up in court, but at least you have it. So why not get it? Now, this is certainly not necessarily true, or would be my recommendation with employees when there's issues, that there may be collective bargaining issues in asking for waivers in uncertain situations, et cetera. But you're going to have to just use your judgment. So I'm not going to go into the features of waivers, but again, any questions about the digital? We're going to try and move to the digital. It's taken a while, mostly because just things have been very busy. So I'd like to move on, because we're getting close on time here, to questions and answers. So if there's anything that I haven't covered that you are curious about, or anything that I have covered that is totally confusing to you, which I'm sure probably is. Anyone?
I'm curious on the retention part. You were saying that they never expire unless they are designed for a particular time period.
Right.
One of the things I do is we do the membership sales here at UC Santa Cruz. So the waiver that they sign when they purchase a membership is only for that time. Is that how I'm understanding it? And that's why we're supposed to get a signature on a waiver and liability each time we sell them a membership, or is there another way of doing it where they only have to sign once for ad infinitum?
Well, I think there's a lot of programmatical challenges in just saying that one waiver will be good forever. Number one, so while legally waivers, if they're worded properly, would never expire, on the other hand, programmatically, number one, you don't know if maybe that person got missed the first time around and they didn't sign a waiver. Or maybe the waiver that they signed was not worded in a way that didn't include facilities, or somehow is otherwise problematic. Maybe they signed it when they were a minor, and you didn't realize that they were a minor. So I think it's good policy. I certainly wouldn't question the policy of just having somebody sign the same waiver over and over, every year when they renew their membership. There's no harm in it, I don't think, and I think it kind of does deal with some of the issues of maybe the prior waiver isn't going to hold water. Okay.
Thank you.
Mm-hmm. Questions on waivers?
Yeah, Nicole, I have a question.
Yeah.
Earlier in the presentation, you were talking about the Tunkel situation and when you should not be asking for waivers. And you talked about academic classes and requirements for academic classes. But it seems like, if my memory serves me right, that one of the UC waivers is specifically for required academic activities. So does that mean that we shouldn't be using that type of a waiver?
Yeah, and that one's coming out.
Okay.
Coming out. I've spoken with some of the attorneys that kind of put those waivers together, and they agree that there really is no reason to have them.
Okay.
I think it was done in abundance of caution, but yeah, it would not be considered a valid waiver by a court.
Thanks.
Mm-hmm. Any other questions?
Yeah, I have a question, Nicole. We have a waiver for facilities use for the recreational facility, and it names the department, the Office of Physical Education, Recreation, and Sports. And Jennifer Yeager had made a note to ask if that is, if that seems sufficient, if that the waiver names the department, but it's the waiver that they're signing as they come into the facility and use the facility.
Yeah, I would have to see the actual waiver, but
okay.
But just kind of as a general rule, it should name the proper legal entity. So the department is not a legal entity, unless there are some departments that have kind of a separate legal entity, like ASUC. Berkeley, I don't want to get off on a tangent here, but normally with our university, it is the regents that are the proper entity. And so the risk that you take by just naming a department is that then when they go to sue, they are suing the regents. Those are the only people that are the only entity that is suable at the University of California. And so there could be some argument, well, no, this was a waiver that didn't even apply to a legal entity, and so it's not valid or for whatever reason.
Okay. So, yeah, so we'll have to have this reviewed more specifically.
Yeah, and you can send that to me. I'm happy to look at it.
Okay, thank you.
Any other questions?
If there are no further questions, thank you everybody for joining us. We hope to see you next month for the next Toolbox. And I think that's it. Thank you, Nicole.
Thank you.
Thank you, Nicole.
Thank you.
Thank you very much.